Participants, those who have joined, I request please wait. Others participants are also joining, and the guest will also join the session within a few minutes. The session will start at 2 p.m. We are waiting for other participants to join. Good afternoon, ma'am. I am audible.
Hi.
Hi.
Just one second, I'm setting up my camera and everything. Just 1 minute.
Okay, ma'am. Sure. I request the participants who have joined, please wait for a few minutes. I have shared the meeting link with other participants also. We will wait for a few minutes. Other participants are also joining, and then we will start the session.
Hi, can you see me? Can you hear me?
Yes, yes, you are audible as well visible. Yes.
Okay, just 1 more minute and yes, now it's perfect. So let me know once everybody is joined and you want me to start.
Yes, few participants have joined. I am waiting for the other participants. We will wait for 1 or 2 minutes. If they join, well and good. Otherwise, they may join in between the session, and the recorded session will be available on the YouTube, so they can watch from YouTube also.
All right.
We can wait for 1 or 2 minutes. Some participants are joining. I think we can start the session if you wish to. Other participants, only two to three participants left. I guess they can join in between the session.
Okay, so would you be okay by sharing your screen for the presentation?
Yes, is it you who is going to share, or should I? You can.
If you can share it from your end so
Just
that, otherwise screen control and speaking will become very difficult.
Is it visible?
Yes, perfect. So, shall we start?
Yes, yes. A very good afternoon to all of you. My name is Varun Kumar, advocate and founder of Law Audience. Today we are organizing a session on athlete, coach, and endorsement contracts, navigating commercial rights, NFTs, and personality protections. And today we have a very special guest with us, Advocate Arunima Jha. She has a very vast experience in sports law and she has drafted contracts for various well-known athletes. So I request the ma'am, please take over the session and you can proceed with the session.
Thank you for having me here, first of all. And let me just begin by saying that you're doing a a wonderful job by sort of, spreading the legal awareness. So thank you so much. So let me just set the context by saying that, imagine that if you are a star athlete and the world knows your name. Your face is printed on jerseys, video games, there are, energy drinks, and even there are cards online. And imagine somebody finding it, that image and turning it into an NFT. And that somebody not just turns it into an NFT, he sells it and he profits from it. And you are not even asked. So, can you sue them? So, today we are going to understand what rights do you have, actually over your own identity in the real world and the digital world. Also, we will look into the sports law where contracts, personality rights, and even the NFTs sometimes they collide. If we can go to the next slide. So
Yes, ma'am.
let's begin with the basics. Okay. See, sports law is not a standalone statute, at least in many jurisdictions. In fact, it's a confluence of many legal domains. You talk about contract law, you talk about employment law, intellectual property law, competition law, and also the data protection laws right now. So it's a confluence of all these domains. And India, as of now, we do not have any dedicated sports law statute because but then there are various Supreme Court and High Court judgments which have shaped the field. The courts have time and again upheld the image rights of, celebrities and even the athletes under Article 21 of the Constitution. The courts have recognized personality rights as an extension to the rights of privacy and dignity. Now, if I have to, just one second. So if I have to talk about, the kind of contracts that we do in the sports arena, there are basically three types: athletes, coach, and sponsorship and endorsements. Athletes are, basically it will govern the terms like, what are the payment to it given to that person, what are the training schedules, if there is an injury protection, how you are going to use the image, and if there is any morality rights that you want them to waive, or do you want to retain a part of it, uh, giving them also a limited right, or and what about the termination right? So these are basically covered under your athletes. When I talk about the coach contracts, now you would have seen the advertisements for Mondelez when they were selling. They were coming out with this video. You will find it on YouTube as well, where different coaches have come and spoken about the cricketers that they had trained, and I did the contracts for them, and if it was basically them talking about their experience, but it was very different from the athlete's contract. We did both parallelly. And my coach contract included the role of the coach, if there has to be any, performance. benchmark. Now, this is in specific to contracts where I want the athlete to perform, not otherwise. And if there has to be an exclusivity clause, because if I want that athlete to only be related to my brand, then I'll have to have an exclusive clause in that. And then it would also offer often span into multiple seasons. I've done IPL as well matches, so you enter into one contract which will again span into multiple seasons, like I said. And then we have sponsorship and endorsement contracts, which is your brand promotion contract. Now, these are commercially very sensitive because then you're using your athlete's name, you're using their likeliness, you're using their voice, their social media persona, and also increasingly, if you've seen, this also covers their digital avatars. You We also have video game likeness and now NFTs, which is non-fungible tokens, right? Okay. If you can just go to the next slide. Now, before I get into the specific of sports law and the key laws, which is the slide after this, let's talk about the personality rights, right? Because in India, we don't have a statute, a specific dedicated statute that defines personality right. But like I said, courts have recognized them. You have your tort of misappropriation. You have Article 21, where the courts have said that it is an inherent part of right to privacy and life and personal liberty. Then you have, several sections under the Copyright Act, Trademarks Act, and even the Consumer Protection Act. So when misleading endorsements are made, you can sue a particular brand for that, for the same reason. You would have seen it in case of Titan versus Rajnikant, right, where the Madras High Court had held that a celebrity's name and image can't be used without the consent, even if it is a fictional representation. You will have to seek a specific written permission from them. Um, Now globally, if I have to compare this globally, these are more codified vis-a-vis Indian laws. I mean, in US, US has different federal laws, state laws, right? So right of publicity, there is a right of publicity statute if you move to California, for example. So they give at least 70 years of posthumous rights to celebrities. So you can't just use them whenever you want. And even under the European Union, the GDPR, you can't use identifiable personal data like a voice or a face in digital products like NFTs, which will attract regulatory action from the authorities. United Kingdom also enforces IP, defamation, and privacy torts. Japan and Singapore have been incorporating digital likeness under image rights, and there are then they have their specific digital protection statutes frameworks. Um, okay, if we can just move to if you can move to the seventh slide, which is understanding the NFTs.
Is it visible?
I'm sorry. I'm sorry. I'm not going chronologically. I'm just trying to see how we can understand it in a flow.
No issue.
See, when I talk about NFTs, there a lot of people have called them as disruptive. NFTs are the non-fungible tokens, and they are governed by your blockchain-based. I mean, these are blockchain-based digital assets. So an NFT is non-fungible, meaning it is unique and it can represent a video of a game-winning goal, or you can have a digital player card. You will have a 3D avatar, which will again wear your athlete's favorite gear. You may have seen Salman Khan and other celebrities in India also talking about NFTs, and even Facebook, if I'm not wrong, 4 months back, Meta had come out saying that they want to launch NFTs on their site where you can create your own digital avatar and you can sell it to other people. So athletes today are being tokenized. I mean, literally, because their image and their iconic moments are sold on. We You would have seen platforms like NBA Top Shot. So you can go and see an athlete's top moments over there. You have radio, also a different website. Now these are again US specific that I'm talking about. In India, NFT is still a very gray area, as in we do have our IT Act which is covering the cyber fraud, but not NFT in specifically. So there is no dedicated NFT law, if I have to put it that bluntly. But yeah, we do have copyright, we do have contract, we have our personality rights, and we do offer remedies in case there is any breach or violation for that. And even the GST Council now treats NFTs as digital goods. You would have seen in many budgets they have coined the term NFTs, and taxes may apply. If I talk about the United States, the SEC is still investigating whether NFTs are securities or not. European Union are reviewing their classification. They have a Digital Services Act under which they are still, trying to see how can they categorize it. And if I talk about China, China has a banned. They had banned crypto NFTs, but they are allowing digital collectibles, which is again state monitored platforms. So now if I have to see, let's say a platform is minting a digital card using an athlete's image without consent, right? Now this is perfect for a legal stop. I, as a lawyer, what can I do? Because I have, if a client comes to me, then what do I need to look into? I have to see, because that there is a IP violation, because if the image is copyrighted or not. So that's the first step to check. Second, if the personality rights are breached, then whether any consent was taken. We had a situation where somebody's image, he's a stand-up comedian, his image was printed on a newspaper without his consent. He had a contract with the brand, with the television, that he cannot represent any alcohol-based category, and his picture was then printed on a newspaper along. And he was, while he was not holding the alcohol, there was a bottle which was printed next to him. So that that meant that he has breached his contract with the channel. Now, this is again a very gray area. So you'll have to see whether we have taken consent, specific consent or not, because that collateral, when it was prepared, it was given to him on WhatsApp. And I don't know if he saw what kind of image is going to go out, but he said, yeah, I'm okay with that. And it was only the picture that was sent to him. And next day, there comes the Alcobel brand next to him, and then there was the whole hoo-ha with the channel. uh, Again, with the data protection issues becoming more and more prominent, you have to see if there are biometric identifiers like voice or 3D face scans, because there are AI tools to do that today. And it could also mean that you may also have to look into if there is any misleading advertisement, as in if the athlete appears to endorse the product, so falsely. So we have seen, influencers or athletes who are now active on Instagram as well, where they come out and say, "Hey, this is the best product on the market." Or let's say, you have a charger for your Apple phone, and you say, "This is going to charge your phone in next 20 minutes," where the charger is taking almost 1 hour. So those kind of advertisements or endorsements are misleading in nature. In India, an athlete can sue for tort of misappropriation. You can seek an injunction in the civil court. You can file a complaint under the Consumer Protection Act if there seems to be a deceptive marketing, and in some cases, even under the IT Act, if there is a impersonation or identity theft, so you can do that as well. If I have to talk about specifically, I mean, as legal professionals, what's our job? So, our job is to ensure that our client's digital identity is protected just as fiercely as their real world rights. So, your checklist is going to be, you will have to include NFT clauses in all your contracts. You have to mention tokenization rights, you have to mention royalties, you have to mention resale terms, and you also have to conduct due diligence on any platform which is entering into a contract with your client and which is offering NFTs. Uh, Now you would have also seen smart contracts, taking over. Now smart contracts are embedded in NFTs. I mean, they do determine royalty flow and how the reuse happens. Again, you have to register IP rights for the name, images, logos, and even sometimes gestures. We have seen movements and gestures which are now trademarked. In the US, it is very common. Um, Again, tax implication, very important aspect. Whether you are earning any revenue from the NFTs, can it be taxable as capital gains or royalties, or can it be called as business income? So those also you need to put into your contract. And most importantly, because I'm a privacy lawyer as well, so I love having a specific covenant for the data laws, ensuring that there is a compliance with data laws, particularly in the NFT. If you are including any facial scans, you are including signatures or any sort of personal data which can be identifiable. Um, Now, see, uh, if you can move to the ninth slide, Varun.
Yes, ma'am.
Yeah. So, see, these are some of the laws that we have already spoken about. But what happens in case, your client's identity has already been tokenized or been exploited without consent? What can be the legal remedies for that? Injunction from the civil court. You can seek monetary damage. You can, at least under the DMCA in the US, you can also issue takedown notices for if there is any US based platform. You can also send cease and desist notice. You can file consumer complaints for misleading, representations, or you can file criminal complaints also in some cases where there is a misappropriation or identity theft. In India, because again, we are in a digital era, so courts are also increasingly issuing global takedown orders where, if you're getting an order, it's not just a takedown in your jurisdiction, but it will be enforceable across global jurisdiction, including your websites, including your NFT marketplaces. So that's a good thing now. Now, if I have to speak about how athletes' performance has shifted to chronological, has shifted chronologically to a commercial asset, right? So let's look at the 20th century. Sports contract, or any contract for that matter, was rudimentary. And especially in the sports arena, where you have cricketers, you have footballers. Usually these were verbal, and athletes were treated mere performers. So they had their employment contracts with different brands or these, authorities. And as sports gained global attention, because we have media broadcasts, we have sponsorships, we have mega events. Now we have Olympics, we have FIFA World Cup. The athlete's persona has evolved over time, and this has evolved into a market commodity. Now, with that evolution, there needed, there came the need for sophisticated and enforceable legal agreements, and which is why now you see, post 1991, with cricket being a major catalyst, the entry of satellite broadcasting, you have corporate sponsorships, you have league based formats like IPL today is turning athletes into brands, right? You do give, there is a rise in your multi-layered contracts. Meanwhile, globally, jurisdictions have been codifying protections for athlete image, name, and commercial engagements. We do have our own specific recognition under the IP law, labor law, or personality rights, which are covered. But globally, they also have specific personality rights doctrines. Um, okay. Just 1 second. I think we have to. If okay, if I have to speak about, how how legal landscape is when it comes to NFTs, India versus global. See, India, we still do not have a dedicated NFT legislation or any sort of regulatory framework. But yes, we do have IT Act, which provides you the sections on identity misuse, cyber security. We have our Copyright Act, again, likeness or videos that you have seen, and we have issued several cease and desist notice even for that breach and violation. Uh, we have income tax and GST. Now, the treatment of NFT income is still very debatable and it's gray area. I mean, whether you call it a capital gain or service is still something that you have to, um, derive after look deliberate upon after you see the structuring of the contract, the obligations, the representations, what exactly each party is doing. And many celebrities, like I said, have already launched their NFT collections. So Sunil Gavaskar has a digital asset, which I don't know if it is legally protected or not, but yes, the protections mechanisms, they remain ad hoc. Globally, US has NFTs face SEC scrutiny. We have IP ownership in NFTs, which are now litigated. And NFT does not mean ownership of underlying image unless you have that explicitly granted to you by that particular athlete. UK treats these digital property. Courts are now permitting freezing NFT wallets, which are during infringement cases. So they do that. European Union data privacy, like I said, it includes NFTs, especially if there is biometric identifiables or there are personal data which are involved. And China, again, I already mentioned that it bans crypto, uh, but then it does allow state licensed digital, collectibles. Um, Now, if I have to talk about what personality rights and NFTs are in sports and what are the strategies around it, now as athletes are turning into digital age celebrities, you would have seen Instagram ads, collaboration. You have seen monetizable brands, the persona, which are now compromising name, image, and even the unique gesture. You would have seen GIF, you have seen stickers. It becomes more than identity, right? It becomes their property. Now, with the rise of NFTs, which is again non-fungible tokens and your digital asset, this property can now be tokenized, it can be traded, and it can be monetized in ways that were previously unimaginable. We have seen NFTs of some meme being sold as high as 9,000 US dollar. We've seen that. So the convergence of sports and IP and the digital technology, it presents a very unique legal challenge because across jurisdictions you have courts, you have regulators, and we are, as lawyers, we are still grappling how to protect personality rights in a world where a single highlight reel can be minted into an NFT and said without minutes, sometimes without the athlete's consent. So it can also there is a potential disruptive of aspect of NFTs as well, if we compare the Indian and globally the legal position. And there are strategies to safeguard athletes' digital persona, which is again, uh, you know, because this entire landscape is evolving. So, if I have to speak specifically about personality rights, which is the right of publicity, it refers to exclusive right of an individual to control how commercially you can exploit and mint their use of their, use of their identity in sports, It means how do you control your name, your image, your likeness, your voice, or even your signature, which can be used for marketing or merchandising. We have seen merchandising, right? And digital engagement. So that's there. India, because the personality rights are not codified, but they are derived from, protection from the Article 21 of the Constitution, or tort law, or, the evolving case laws. It is still something which is a very gray area for us, but you can look into the case of, there is a DM Entertainment case, there is a ICC development case. Now these have recognized publicity and image rights. In the US, these rights are recognized under state specific, publicity statutes. California has the California Code of, section 3344, I think. So EU also protects identity under the GDPR, like I mentioned before. So these are some of the aspects of, NFTs. And then again, understanding NFTs are very important because these are unique, these are non-interchangeable, and these are built on blockchain. So unlike your cryptocurrency, NFTs carry a very unique digital signature, and often it reference. I mean, if there is a reference of digital asset like video, image, or music clip, so it makes it more challenging. The core features of NFTs are it is immutable record on blockchain. So if you are buying something, your data of your, PC is available to somebody across, to different global jurisdiction. I can see it from even from a different place. And then we have smart contract, which enables the royalty split. We have unique ownership tracking. I can see where this NFT is owned by whom. And then there is a tied metadata which details your rights, your creator info, and also certain usage term which is related to it. If I talk about use cases in NFTs, so we have to look into uh, the top shot of NBA that I just spoke about, right? You have a tokenized game moment. Then again, we have fan engagements, which are tokens which are enabling team voting or backstage access. We also have ticketing. So NFT based event tickets with, programmable, features are also available. Then we also have virtual merchandising, which is you can have, metaverse jerseys, you can have avatars, you have emojis, which are, available for usage. And then we also can earn, as athletes. I'm talking as athletes. Say we can earn from both primary and secondary NFT sales, and also via smart contracts. Varun, if we can move to, the next slide. Next to next slide.
Next to next, this one.
Yeah. So see, uh, you know, there are legal risks also, which are, you know, which are linked to the common violations of NFTs and the infringement of personality rights, as into tokenizing of athletes' face, voice, or name without consent. Then selling NFT, implying false endorsement is one of the very challenging area. We have seen that. We can also see using avatars or AI voice clone based on real athletes, deep fakes, right? You've seen that. And then monetizing in game or metaverse likeness post contract expiry. Now, whenever we have an endorsement contract in place or brand promotion that are limited to a particular, period, so even reposting is not allowed. So you can't really. Will you just give me 1 minute? Sorry. So sorry. Um, yeah. So, Okay, this is the global perspective we were discussing. Now, if I have to talk about the Indian perspective, you can bring in a claim under tort law. You can have an IT Act which can be invoked if there is any identity misuse or there is any cyber impression, and there is uh, no interim regulatory body if you have to bring in a specific claim. But IP tribunals usually they do hear your NFT related disputes. And like I mentioned, when we sign endorsement contracts, those are limited for a specific period, so you can't really repost a reel and then commercially gain or you mint money from that. Globally also, it's not like everything is perfect. There are gaps. I mean, US, for example, state rights, it does vary. Some states offer posthumous protection, others don't. European Union, data rights are easier to enforce than image rights unless it is harmonized. Cross border platforms, again, they often dodge enforcement because unless they are subject to specific local law or specific IP law within your jurisdiction, it's very difficult. And so what are the strategies that can that you need to include when you are preparing the paperwork for these kind of contracts? So you have your name rights, which will cover your legal name, nickname, phonetic variations, and even the team link identifiers for the athlete. You have your image and likeness. So that would cover your photos, video, digital avatars, and silhouettes. You have your voice rights as well. So this will include your distinct voice patterns. If there is any catchphrase, if there is any commentary style that you want to protect, so that also you have to cover. And then again, signature rights and gestural rights. So signature would be your autograph or digital signature, any sort of personalized logo that we use for some athlete, and celebrity gestures. So for example, there is you've seen Hussein Bolt's lightning pose, right? So that's something which is already protected by the IP. It's already trademarked. And then you have your routines, you have your recognizable styles that you need to protect. If I speak about the monetizations from personality rights, which is from endorsement to digital assets, now look, historically, athletes have monetized their identity through endorsement deals. You have seen media appearances, you have seen licensed merchandise, you have seen but with the arrival of the internet and social media, these have just expanded. So today, you can see a digital revolution. Specifically, NFTs has fundamentally, it has altered the landscape. uh, so we have traditional media, we have digital media. If I talk about the traditional channels where we have TV ads or print ad campaigns or brand merchandise, you can also see the trading cards which are there on your traditional channels. Modern streams, you would have your video game likeness rights, you have your branded apps, you have your personal vlogs which are there, and then again you have your AI voice integrations which are there available in different apps. And NFT drive, there can be an NFT driven monetization. So you can tokenize your highlight reels, you can have collectible digital cards, virtual meet and greet, and metaverse appearances. So I think if there is any question until as of now, because this is a little complicated, so any question that anybody has.
If any participant wants to ask any question from the ma'am, please unmute your mic or raise your hand. Till now, if you have any question, please ask. You can also write in the chat box. There is
I
no
think
question.
Aishwarya has raised hand.
Please unmute your mic and you can ask from the speaker.
Good afternoon, ma'am.
Hi.
Hello, ma'am.
Can you hear me? Am I audible? Yes, I can hear you.
Yes. Ma'am, I just had a question. So, when the international athletes, when they are signed by IPL teams, so you can say RCB or any team, then how are the jurisdictional and IP clauses actually, like especially in relation to say personal endorsements or NFT based licensing? So, how are these clauses navigated? Like, how are these clauses negotiated? And because there is an intersection between, say, I mean, the Indian laws and the foreign laws that the athlete is subject to. So, I had a question with respect to that. If you could let me know.
See, Ashwarya, excellent question. Okay, and that's really sharp. Now, let me break it down. When an athlete signs a personal endorsement deals, right, or they license their persona for use in NFTs, the agreement will cover your jurisdiction. It will cover your governing law clauses as well. And personality rights are not something which you can uniformly enforce across jurisdiction. NFT platforms are global, and so is your IP infringement. So many athletes, not when they endorse, they earn both from India and internationally. Now, the what we look into is governing law. So, which country law will be applicable in case of any dispute? What happens? Where will I, get it resolved? If so, for example, if an Indian cricketer for me is signing a licensing deal with an American NFT platform, you may want to look whether an Indian law will apply to personality rights. Or let's say if the platform is Delaware based, okay, or New York based, then as a platform, I can push for that specific US law, right? State law, which is very common in your tech and IP contracts. So, and many a times we have also compromised to a neutral jurisdiction like Singapore, which is your SIC, or London, LCI. So well, that's about it. And as far as enforcement in cross-border contracts are concerned, because India recognizes personality rights under the Article 21 of the Constitution, like I said, right, Indian courts are more sympathetic to claims of misuse, even if the violation happens digitally. So if the NFT, but again, if the NFT is minted in the US, Indian athlete may need to enforce their rights under the US law. And US, honestly, they it doesn't always recognize personality rights under the right of publicity law, because then it varies from state to state. So when I have to look into the jurisdictional of IP clause, I will see where the residence of the athlete is, where the domicile of the platform of the brand is, where the IP is exploited or sold, and if there is any sort of precedent of enforcement in the territory. So we do our research in that, and like you know um, publicity rights again are governed by state laws in the US. And FT licenses, again, it often refers to your contractual representation. So it's not an automatic statutory rights. So you'll have to explicitly define what IP is being licensed. I mean, are you only giving an image, or are you giving voice, digital avatar? Is there a geofencing restrictions? If there is any do you need to specify exclusivity zones, those kind of things. So you have to be, so just to summarize, you have to be clear on what law is governing your personality rights. Negotiate your dispute resolution to a neutral and tech friendly jurisdiction. So for me, if I have to choose a jurisdiction even in the US, I first opt for Delaware. If not Delaware, then I go for Minnesota. If not Minnesota, then I go for New York. Or even if that is not applicable, then I move to any other place. But California is still a problem for us as lawyers. So you have to negotiate a dispute resolution jurisdiction. You have to specify your scope of IP and digital use and moral right disclaimers, especially because if you're talking about art or you're talking about NFT context, so you need to have those compulsorily, and compliance with DPDP in India and GDPR in EU. So does that answer your question?
Yes, yes, ma'am. Thank you so much for your insightful answer.
Any other question?
No, ma'am, I don't see any question in the chat box. I guess some participants may ask in the end of the session.
Sure. Okay, so now, look, we have spoken about NFTs, we have spoken about IP rights, but let's also talk about how do you how do you have how do you separate personality rights from commercial exploitation. I mean, understanding what personality rights are only the beginning. So if you want to look at how these rights turn into real world value, how fame becomes fortune, especially in the world of sports, you have to look into the contract. And contracts usually cover what's already visible. So for example, endorsements, gameplay, and media appearances. But if you're not covering NFT, so what happens if NFTs or any aspect, any image or likeness is being digital tokenized globally? So this is a very wild world, and you can read Titan versus Rajnikant. Like I said, it's very interesting case. You can also see, the real life examples. So I've worked with, a deal where Virat works with HSBC, and this is a micro anecdote to sort of bring concepts to life. So they create visual memory and sort of emotional connection. So again, you have to see whether there is any indirect reference, or can that indirect reference, to be more specific, violate personality rights. So for example, what happens if I create a meme using that, or I create a game using that? Okay, now this is where the court would step in, and this is where you need to have a very you need to emphasize what are the do's and don'ts, and what can be, you know um, what is acceptable and what is not, whether you are okay with this being licensed, or you want it to be a limited license, you want to protect, and you want these property to be respected. So those are there. Now, the future of sports law, to be more specific, isn't really about stadium anymore or sponsors or scores. It's about avatars, it's about algorithm and authenticity. As lawyers, our role is evolving. We are not just the defenders of contract today, we are the defenders of identity in a world which is digitizing everything that we value, right? Um, so, I would really like to hear your questions or any sort of real world example. So, let's open the floor, because I see we have 10 minutes left now.
Sure. Aishwarya has some question. You can unmute your mic.
Yeah.
You are not audible. Aishwarya, you are not audible.
Okay, okay. I'm so sorry. Am I audible now?
Yes.
Yes. So, ma'am, I was just thinking about this that, in scenarios where athletes' personal endorsement deals, like you can say Virat Kohli. So, what if his, personal endorsement deal is in conflict with, say, RCB's commercial arrangement? So, there is a conflict. I mean, I'm just imagining there could be a conflict arising there. So, how, yeah, I mean, are there any negotiation strategies to help mitigate such conflicts or such risks, or how is it actually, done? So, just if you could, let me know.
See, Virat, wears multiple hats, right? He's a national team member, he's an IPL franchisee player, he's also a personal brand ambassador. So, and conflict between personal endorsement and team commercial deals happens more than people can even realize. Imagine Virat going and endorsing Puma personally, but RCB's team sponsor is Nike. Just hypothetically speaking, and Kohli promotes, or Kohli promotes Mintra, for example, and RCB has an exclusive deal with Agio. So here, there is a conflicting brand visibility, and this can dilute your commercial value for RCB, or it can, also mean that there is a breach of exclusivity obligation. Usually, team contracts with RCBs, they include a clause that will put a restriction on them saying that the player cannot endorse any competing product or brand in conflict with the team sponsors. Or they, sometimes they even provide a carve out, providing that players' existing individual endorsements as of the date or this agreement shall not be deemed as breach. I mean, today you could have done some endorsement, and let's say today he they are still promoting that endorsement and you sign a contract with them. So you need a carve out, right? And contracts where we have seen specific brand categories, for example, footwear or beverage or fantasy gaming, right? There is a priority clause that we put, and we also put a non compete window. So we say that no conflicting deals will be done during the tournament period, and if there is any dispute or conflict between the brand and the team sponsor, then the brand will take precedence over team sponsor or vice versa. So that's something that you need to discuss and negotiate. Uh, if if the personal brand cannot be dropped, I mean the players are asked to remove branding during team events or interviews. Um, that can be done, but or you can allow neutral clothing when you're representing the team, right? So as from athlete side, you have to disclose if there is an existing deal before signing the team contract, and you have to do a conflict check, also a due diligence obligation on the other side when they are entering into contract with you. That's very normal. And senior players like Kohli may negotiate that personal endorsements would override team obligations in specific categories. So uh, any new personal endorsement during the team contract, um, they can get prior written approval from the brand or the team, sorry, from the team or franchisee. That can also be done. So you can have a mutual approval, right? In 2009, if you remember, Sahara India, right? Sahara was the India team sponsor, and Sehwag had a personal deal with Hero Honda, which was a competitor. It triggered a whole debate on commercial conflicts and team versus personal endorsements. And there, if you see even today on the news, you'll find that they had discussed. There was a whole legal saga following that. So these conflicts are foreseen and they are negotiated in advance. You need to include prior approvals, category exclusivity grids, which are the key obligations, right? And for elite athletes, your bargaining power decides whether you want to do personal or team obligations when I talk about the precedents. Does that answer your question?
Yes, yes. Thank you so much.
If
Anybody
any,
else who
yes, ma'am. If any participant
and
wants to ask any question, please unmute your mic and ask directly for ma'am, or you can write your question in the chat box. I will pick up and ask from the ma'am. We are open for the question and answer session, and only few minutes left to end the session. You can write your questions in the chat box or ask from the ma'am. We will wait for a 1 minute if you have any questions.
now since till somebody asks a question,
Okay.
just to elaborate on Ashwara's point, which was more specific to India, let me also touch upon the international law considerations. What happens there is a jurisdictional IP ownership. I mean, what we essentially do in endorsement contracts, we define whether rights will apply, whether it will be globally or it will be territory specific, like India only. So conflict can also arise when there is a global sponsorship rights, which extends into market where the athlete already has a local conflicting deal, which you need to check. And if somebody is selling NFT featuring the image, his image via a personal blockchain deal, and let's say the team is selling some other team NFT. Okay. Now, here we can also have a duplicated right usage, which can lead to IP infringement claim or loss of exclusivity. And there could also be a claim for violation of image rights. So, modern contracts are now explicitly covering your metaverse, your NFTs, avatars, gaming representations, etc. And for you to mitigate the risk, there are different strategies. You can use comprehensive image rights contract. You can have you can obtain pre-approval rights for all your personal endorsements. You can also limit your player appearances in conflicting brand gear during team events. These are some of the strategies that you can involve for uh, this is for franchisees perspective. If I'm talking about athletes, you can hire you know your first step is to hire an IP sports lawyer. And then we move to the written consents or waivers, and then we also can build in any sort of prior deal exemptions, which are in every team or franchisee deal that we can put. And you can see when MS Dhoni and Amrapali did an endorsement, right? So there, I think they endorsed Amrapali real estate. Was it later sued them for personal, because personal endorsements can also have public fallout, and taught athletes, that brand these teach athletes the need for brand due diligence that also needs to be it's imperative. If I talk about FIFA, players had to cover personal brand logos during FIFA official photo shoots because official sponsor exclusivity. So that is again there. So the key to navigate these endorsement conflicts is you have a clear documentation, you have a preemptive due diligence, and also a contract that will balance your brand protection with the athlete autonomy. And with the rise of digital assets like NFTs, conflicts are no longer limited to physical jerseys or TV ads. They are expanding into virtual economy. You require more and more sports lawyers. You need agents to be sharper than ever. Right. Any question till now?
No, ma'am.
Okay. I you know we have a conflict avoidance clause included in all our athlete endorsement contracts. Okay. And let's again giving you an example. Let's say Virat has a this is hypothetical. Virat has a long-term personal endorsement deal with Puma, and RCB signs with Adidas, which is their official team sponsor, including, let's say, team jerseys, shoes, and casual apparel. You would want to add a carve out. Okay, let's look at that. Look at it this way: Adidas wants every RCB player, including Kohli, to wear only Adidas branded footwear for all the promotional events and even official team activities. But Kohli has a exclusive deal with Puma, which restricts him from wearing or promoting competitor apparel. Now, here Kohli's Puma deal precedes the Adidas RCB deal, and it includes an exclusivity for footwear and apparel. So you need to have a carve out in the when you're signing contract with Adidas, which allows Kohli as an exception. And RCB can then adjust promo shoots to exclude Kohli's feet or footwear when there are Adidas's branded campaigns. And Kohli might also agree not to actively promote Puma in RCB team shoots, which is a very neutral brand positioning. So as if you are from the player side, you have to ensure that his image rights, Puma's usage rights are protected. And RCB includes, a grandfather clause. So I don't know if you are aware, there's something called a grandfather clause, which is basically something which is a set clause for all your future contracts to sort of avoid any pre-existing obligation. And we have seen this a very common situation especially in leagues like IPL, FIFA, NBA, and again the key is timing of contracts, category exclusivity, if there is an IP overlap management, there are any pre negotiated exemptions. So those are the stuff that you need to look into when you are drafting the legal paperwork. Any questions? We are, no? I think we are close to the session. So, anybody who has any question?
I don't think participants has any question as of now. If any participant has any question, uh, only 1 minute left. Please ask your question, or you can type in the chat box and ask directly from the ma'am. Otherwise, we will end the session within a few minutes, and the all those participants who have joined the session, they will receive their e-certificates within 24 hours. And if you have your feedback regarding the session, the video will be available on the YouTube channel. You can post your feedbacks on the comment section and by visiting our YouTube channel. Ma'am, I think we can end the session if it is okay with you.
I'll just end it in. I have one, you know, something to say before we end, right? To wrap the session. See, today's commercial sports ecosystem, where athletes are acting as both powerful brand, you as lawyers, you have to manage conflict between personal endorsements and team sponsorship, which is inevitable and also essential. And the way to do it is you need to have a clear contractual language, you have to have a proactive disclosure and a pragmatic negotiation strategy that will not just balance the player's individual right but also the institutional interest. And as legal advisors, as lawyers, our role is to foresee potential overlaps. If we can draft any flexible yet protective clauses and also guide athletes and teams through these gray zones. This will also ensure that brand value, legal integrity, and public image of the player, the athlete, the sports person remains uncompromised. So I'll end on that.
Thank you, ma'am. Thank you very much for your time. We will end the session and we will post the recorded session on the YouTube within a few hours. Thank you to all the participants for joining the session. Thank you, ma'am. Thank you very much.
Thank you. Thank you, everyone. Thanks, Varun.